Hello, everyone. This is Courtney Steelman, attorney in Husch Blackwell's Labor and Employment Group. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions specifically for any of the presenters during the webcast, use the Q&A icon to submit. We will try to answer all questions during the webcast today, but if a fuller answer is needed or if we run out of time, it will be answered later via email. A PDF of the presentation is available in the resources folder. This program is pending approval for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. That's all for the housekeeping items. Let's get started with our program. Joining me today are Rufino Gaitan and Brian Hendricks. Rufino has dedicated his career to helping employers map out optimal paths to resolve staffing and compliance issues with high-stakes outcomes. Brian advises clients on environmental, health, and safety law with a focus on litigation, incident investigations, enforcement defense, and regulatory compliance counseling. So let's hop in. Over to you, Brian.
Thank you, Courtney. Good afternoon, everyone, or morning if you're in a different time zone. I want to start with by addressing what I would consider to be, I guess, the most recent development, and that is simply that OSHA, as of this morning, has gone ahead and announced that it is suspending enforcement and implementation of the ETS. Now, the way that it did this is it published it on its website. It had previously, as of yesterday or day before, said that it was not going to take any action that would be in violation of the Fifth Circuit Court of Appeals order directing it not to take any action to enforce or implement. We're going to explain what this really means in a bit and go over the host of legal challenges that OSHA is currently dealing with, well, throughout the country, but it's been recently consolidated rather in the Sixth Circuit Court of Appeals. But I wanted to just say right off the bat, we're aware that this has occurred, that OSHA has made this announcement, and we're going to address it. So with that, let's turn back to the presentation. Actually, I didn't share my screen, so you didn't get to see that. But if you go to OSHA's website, and it's also available in the tabs to the right, if you go to OSHA's website, you'll see the statement. And it simply says that OSHA isn't going to implement or enforce the requirements of the ETS in the short term pending additional legal developments. All right, with that, let's turn to the ETS itself. So OSHA published this on November 4th. It was official on November 5th, and it was published and effective that day on November 5th. The new emergency temporary standard applies to all employers who are regulated by OSHA, and we'll get to that and cover what that means in a bit, but with at least 100 employees. How to count those employees we're also going to address. What OSHA has done is it has basically left it to the employer to decide whether the employer will offer its employees the option to be vaccinated or tested, or if the employer makes the decision or goes this route to just allow employees to be vaccinated. And before I go on, Rufino is going to address exemptions, religious and medical exemptions, and how you handle those. If you're an employer who decides that you aren't going to offer a testing option, employees will still have the option to apply for a religious or a medical exemption, but Rufino will get to that in a bit. In addition to frequent testing, once a week testing, or vaccination, the rule also requires certain record keeping to be undertaken by the employer to report certain outbreaks or positive cases. And there's several other requirements as well with record keeping and reporting that we'll go over. A topic that Courtney is going to cover is the cost of testing. And the rule requires cost of testing and, vaccination as well, requires you to provide paid time off for purposes of getting vaccinated. And it also requires you to provide paid time off or paid leave for employees who suffer ill effects after they are vaccinated from the adverse effects of the vaccine. So again, the ETS, it places the burden of compliance and record keeping on employers. It leaves the employer to decide whether the employees are going to have the option of testing or vaccination. So again, you can, as the employer, make the decision to require all of your employees to be vaccinated, again, except those that actually file for or request a legitimate religious or medical exemption. And it also allows you to require them to be tested once a week, once every 7 days, again, except those who are exempted, and to wear a mask. So if you choose not to be vaccinated and your employer permits that, or you as the employer allow that, then those employees who aren't vaccinated, in addition to testing, must wear a mask while they're in the workplace. The mask can be basically of any sort. There's not a requirement that they be N95s or respirators or anything of that sort. Cloth mask will work. And you, the employer, may also impose on the employee both the costs of testing and the costs of those masks. That is up to the employer. All right. There are, however, a few workplaces, and I shouldn't say a few, it's quite a number of workplaces, about somewhere between 20 and 30% of the entire workforce in the United States is not covered by the ETS. And that's simply not smaller employers with fewer than 100 employees. It's also all employers who are or contract with the federal government. If you are a federal contractor at any tier, then the Safer Federal Workforce Task Force Guidelines, that's a mouthful, but that's what they call it. We just call it the federal mandate, federal contractor mandate. It applies to your workforce. And rather than a soft mandate, so testing or vaccine, it imposes a hard mandate. And those workplaces, those employees and those employers are not covered by the emergency temporary standard. And all of those workplaces, all of the employees in those workplaces must be vaccinated by January 18th is the current deadline. Another category of employees and employers that the ETS does not currently cover are those that are covered by the January 21st emergency temporary standard. That's what I'll call here the healthcare standard. Now, an emergency temporary standard, the key word there is temporary. All ETSs, this ETS, the most recent, and the June 21st ETS covering just healthcare, they have a 6-month lifespan. They expire, or they die out in 6 months. So if you are in a healthcare, or if you're a healthcare provider, or you're an employee who works in a healthcare setting and are covered by the June ETS, you're not covered by the ETS that OSHA issued on the 5th. You're covered by that June ETS, at least until late December of 2021, because that's when it will expire. And OSHA has indicated that it will allow it to expire. It will not use the June 21st healthcare ETS to promulgate a permanent standard for healthcare. So right now, if you're in healthcare, the June 21st ETS is what applies to you. As of the end of December, though, the current ETS, the November 5th ETS, is what you're going to be dealing with. All right, and finally, it's employers who have fewer than 100 employees at any time at all time while the ETS is in effect. Here's what we mean by that. Well, before I get to the 100 employee threshold, let's think of this in terms of employees who aren't covered. First, there's also exemptions for certain categories of your employees, even if you're covered under the November ETS. to begin with. They would be workers who do not report to a workplace where other individuals are present. So if an individual works at home and is not around any coworker at all, exclusively, they are alone, they aren't covered by the ETS. If they come in at any point to the workplace, or if they are working around other employees at any point, they are covered. Second category is people who work exclusively from home. And again, the word here that want everyone to key on is exclusively. So if they ever come into the workplace or are around other employees, then they must comply with ETS. They have to be vaccinated, or if you offer it, masked and tested. And finally, employees who work exclusively outdoors. Now, the administration has suggested that when they say exclusively outdoors, that this exemption or this exception will apply to individuals like truck drivers and like others, landscapers, that kind of occupation. They've done that with a wink and a nod. They haven't done that officially. We've seen this in verbal statements or in interviews with senior administration officials. I believe, though, if you look at the preamble, or I know if you look at the preamble, that when OSHA uses the word exclusively in the preamble and then describes what it means by using that word, any excursion into an indoor setting, even for a brief period of time, may mean that that individual is not going to be treated as an exempt individual by OSHA at some point in the future. So if you are relying on the exclusive outdoor exception, or exclusively from home, or exclusively alone, to avoid compliance with the ETS, I would just caution you that in the future, and it won't be that long into the future, OSHA may interpret this as it has described it in the rule. I would be very careful about those exceptions. I'm going to skip through here real quick because I want to get to the 100 employee threshold real quick. All right, the 100 employee threshold. We've received from clients a lot of questions about how do I count the employees, which employees count and which don't for purposes of the threshold. Part of the reason that there's so much confusion about this is that OSHA typically, and no other rule that I'm aware of that OSHA has promulgated, sets or identifies workplaces or employees that it covers based on the number of employers or the number of employees that an employer has. There's exceptions for very small, less than 5, less than 10 employees in some of OSHA's regs, but this isn't the way that OSHA normally does business, is my point. So there are a lot of questions. There's not a lot of guidance on it. First, think of it in terms of you count all employees at any location domestically, or at all of the locations that you're responsible for, that you own domestically. So within the United States, if you have, for example, 3 employees at 50 different locations spread across 50 different states, you will qualify or you will pass that threshold. So it is not if you have 100 employees at one site, it's all of your sites in the aggregate. And that's true regardless of their vaccination status, where they perform their work. In other words, it's true if they're employed by you but aren't otherwise covered because they work alone or work from home, you count them for purposes of compliance with ETS for reaching that 100 employee threshold. Part-time employees and seasonal employees employed while the rule is in effect, they count. Now, the key here is while the rule is in effect. So the counting begins on November 5th. If you had 150 employees on November 3rd and you had 75 employees as of November 5th, you don't currently meet the threshold. The ETS doesn't apply to you. However, if at any point during the 6 months following November 5th, so between November 5th and May 5th, if at any point the 100 employee threshold is crossed, the ETS applies to you, the employer, and that will stay true regardless of whether or not you fall below that threshold again. So once you're over, you're always over for purposes of the standard. Employees that aren't counted by an employer are employees of an independent contractor who's working at a facility, also staffing agencies. The staffing agency will count those employees to their threshold. But if you are contracting with the staffing agency for employees, you won't count those towards your 100 employee count threshold. And finally, franchisors and franchisees. The White House, the administration, agreed to exempt or not to count for franchisor purposes all of the employees of each franchisee. So if you're a franchisee, it is only your employees at the franchise that you own that are counted. That was one of the carve-outs, a political carve-out that the White House imposed on OSHA, or that OSHA agreed to. All right, now let's go back now that we've covered the 100 employee threshold, and go over the requirements real quick. All right, first, you need to decide as an employer whether you are going to offer vaccination only as an option, or vaccination and testing. Now, we refer to the option of testing as a soft mandate. So it leaves it up to the employer, and you need to develop, implement, and enforce this mandate within your workplace. You also need to determine the vaccination status of each of your employees. You need to poll them. You need to find out who is vaccinated, who is not. You need to offer, and Courtney will cover this, paid leave for vaccination. You need to establish a system whereby you can periodically test once every 7 days, once a week, employees who are not fully vaccinated, if you choose to offer that. And for testing, and I'll just quickly go over this, the rules for testing are that first, it needs to be FDA approved for the diagnosis, not screening, but diagnosis of COVID. Second, you have to implement, or you have to actually give that test consistent with the manufacturer's recommendations. Fairly simple and straightforward. The third element, though, is less so. And the third element is, as an employer, you are not to accept a test or test results if the test hasn't been either self-administered, or if it hasn't been self-read. So if a third party reads it, but the employee administers it, that's fine. If a third party administers it and then the employee reads it, that's fine. But you can't have both. So a take-home test that the employee takes at home outside the presence of a third party or the employer, and then reports on their own back to you, the employer, that is not acceptable. There is quite a lot of information in the preamble to the rule about testing, the type of testing that OSHA will accept. Broadly speaking, though, if it's FDA approved and it's not an antibody test, it will likely be acceptable to OSHA, assuming, again, that it's not self-read and self-administered. For those of you, for those employees who have employees in areas where tests are not readily available through third parties, there is a telehealth option or a Zoom option for testing. And I would encourage you to look at the guidance on that, and we're happy to answer any questions you might have about that. OSHA has indicated that shortages of tests and the availability of testing, if you are in an area where it's difficult to get tested or you aren't able to obtain the materials necessary for tests, that OSHA will work with you. That doesn't give me a lot of comfort, but that is what OSHA has been saying, at least in public statements so far. So we will see. Employers finally also must require employees to provide prompt notice of a positive COVID-19 test or diagnosis. You can be relying on employees. You'll still want to screen for that purpose. And employers are obligated to remove an employee from the workplace if they're positive. It's also the case that the employer is obligated to remove an employee who won't get tested or vaccinated and doesn't have an exemption. The employee must take action to remove that individual from the workplace. Now, what you do as an employer with that employee, whether they're put on administrative leave, whether they are terminated, whether they are laid off, however you would, whatever your decision might be, that is up to the employer, at least as OSHA sees it. And we'll cover this in a bit, but OSHA has basically punted to employers to decide, okay, how are we going to enforce this if we have, or for those employees who simply aren't going to get vaccinated and will not get tested. All right. We talked about this already, but for those employees who opt for testing, they have to be masks. They have to wear a mask when they're indoors or when occupying a vehicle with others. And there's some limited circumstances that we won't cover here where that's not the case. Now, training is another requirement, and you will need to provide all of your employees with educational information. And this is the language that OSHA uses, in a language that and at a literacy level that the employee understands, covering all of the topics. So the requirements related to workplace policies and procedures regarding the implementation of the ETS. Vaccine efficacy, safety, benefits of being vaccinated, their retaliation rights, or their rights under the OSHA Act regarding protected activity, basically the whistleblower rights, and laws that also provide for criminal penalties for lying to, unknowingly supplying false information, statements, or documentation to OSHA. Now, fortunately, OSHA has provided some examples of the types of information they expect you to provide to your employees, and I encourage you to look on the website for that information. Employees must also report work-related, and when I say work-related, I mean occupational. That word still applies, is still in use by OSHA, still as it's defined by OSHA. So occupational means for COVID-19 fatalities that occurred because the employee was infected at work. So there's a connection between work and the contraction of the disease. However, the change here is that you have to report them to OSHA within 8 hours of learning about the fatality. You also must report work-related hospitalizations, COVID-19 hospitalizations, to OSHA within 24 hours of your receipt of that information. So 8 hours, you must inform OSHA of any fatality that's a COVID-19 fatality, and the disease was acquired in the workplace, and 24 hours within the hospitalization of any employee who is hospitalized because they contracted COVID-19 in the workplace. Finally, Brian, with regard to, go ahead.
On this particular reporting obligation, there is one particular difference in the ETS from the typical standard, right? And that is that the timelines for reporting a fatality would be that if the fatality occurs within 30 days of the exposure of the workplace incident, it would still be reportable. And then from a hospitalization standpoint, it was if it happened within the 24 hours after the exposure, it was reportable. The ETS, at least for the COVID issues, has removed those timelines. So even if somebody dies of COVID and it's a work-related exposure, 45 days after that exposure, that would still be reportable under the ETS. Is that your understanding?
That is correct. No, and that's a very good point. There are those differences, and this rule it did change, or it does change reporting obligations as compared to other occupational illnesses that you would have or would be recordable or reportable to OSHA. So a bit of a change there. OSHA hasn't squared the situations, or they haven't squared up those two different requirements and addressed when one would apply, for example, if the ETS doesn't apply to you for small employers versus for the larger employers. So there's an inconsistency there, to say the least, or there's some gray area there that OSHA has not yet addressed. We can add that to the long list of questions and gray areas that have not been addressed with this rule. We have all sorts of questions, and unfortunately, we don't have nearly as many answers as we would like right now. Thank you, Rikino. Finally, employers must make vaccination or testing records available for examination and copying if OSHA requests them, or rather when OSHA requests them. So obviously, as the employer, you will need to maintain vaccination records for your employees. And we would recommend, or we do recommend, that when you obtain those vaccination records, you note both the fact of vaccination, but also the date and type of vaccination. And here's why. If this rule survives, and we'll go over why I think that is in question at this point, it's a big if, but if this rule survives, it would not surprise us that whether you are considered fully vaccinated or not will depend on whether you've been or received a booster. OSHA has not changed its definition of vaccination or vaccinated, fully vaccinated, and that's defined in the standard. But it wouldn't surprise us if the CDC indicates that full vaccination is something more than just receiving the 1 dose of the J&J vaccine or 2 doses of the other 2 vaccines. So keep that in mind. At some point as an employer, if you don't have that information, you may need to obtain that. I think it's easier at the outset just to obtain that information so you'll know in the future who needs a booster and when. All right, 2 deadlines I want you to keep in mind. And we've seen several questions here already in the Q&A column about, well, if this is suspended, why do we need to, or if OSHA is not currently implementing and will not enforce until further court action, why do we need to be worrying about this now? And that's a great question. And really the answer to it will depend on your situation as an employer. It'll depend on a couple of things. First, let's keep in mind the deadlines as they currently stand. These deadlines have not officially changed yet. The first deadline is the December 6th deadline. This deadline is the deadline OSHA has set for everything but vaccination. In other words, you need to do everything that the rule requires you to do short of having all of your employees vaccinated or tested by December 6th. So all of the training, all of the record keeping work, all of the support that you're going to put in place for employee vaccination. So all of the payment options, that kind of thing, that needs to be done by December 6th, and that date is rapidly approaching. OSHA has not changed that date. Now, OSHA has said that it's not currently enforcing the rule, but right now, OSHA doesn't need to do anything to enforce or to implement the rule. First real deadline is December 6th. So OSHA can say to the world, look, we're going to agree with the Fifth Circuit for now. We're not going to take any action to implement or enforce, knowing full well that it wasn't planning and isn't likely to actually take any enforcement action before December 6th, right? So keep the December 6th deadline in mind because that is a lot of the heavy lifting. That's the date on which a lot of the heavy lifting will need to be done. Now, the second deadline, the final deadline, is January 4th. This deadline also has not changed. This is the final deadline on which you must ensure that all employees are either vaccinated or that they will submit to testing and masking. Now, this again is up to you, the employer, and what you do on that deadline or on that date with employees who aren't masked or will not mask, will not get tested, and will not get vaccinated, and don't have a religious or a medical exemption. That is up to you, the employer. And one of the questions I saw in the Q&A was, what are our options? And Rufino is going to cover that, but your options are similar to, or I would say the same as your options when you are looking at complying with, or an employee who will not comply with, a mandatory safety and health standard of any other sort. So if you have an employee who just refuses to wear a hard hat and safety glasses in an area where they're required to wear a hard hat and safety glasses, what would you normally do with that employee? Now, we know that you have to remove that employee and an employee refuses to get tested or refuses to be vaccinated from the workplace. We know that that is the baseline. What you do with regard to their employment status, though, is up to you. And Rufino is going to cover that in a bit. And this is, so that's the deadlines. Now, I said the January 4th deadline has not been moved yet. I think that it will, if the rule survives. And I say I think, I don't know, so I wouldn't count on it if I were you. But here's why I think that it will change. One, there's obviously uncertainty with regard to whether the rule will survive. OSHA needs to recognize that. But two, the federal government has already moved the deadline for compliance for federal contractors to January 18th. It hasn't done that for this rule, okay? So Previously, they moved the federal contractor deadline up from December to January 4th because they wanted there to be one deadline for all employees in the United States that are covered by either the federal contractor rule, the CMS rule that I haven't mentioned, or this rule. So I think that they will be motivated to move it to the 18th. The reason I think that they haven't moved it, the OSHA deadline, is that, as the Fifth Circuit pointed out in its decision, if this were, as OSHA claims, a grave danger, then OSHA shouldn't have waited as long as it did to promulgate this emergency temporary standard. So I think that OSHA is a little wary of moving a deadline for getting vaccinated yet again, or not yet again, but moving it from January 4th forward, because they have already seen how the litigants are using that to show that that this may not be and that isn't a grave danger. So I think that's the reason they haven't moved it yet, but I wouldn't be surprised if they do. I wouldn't expect them to move it by a lot. So expect that January 4th deadline to move, I think, to January 18th. Now, Courtney's going to cover how much time, who has to pay for what, and what that looks like. So I will leave that to her. Turning now to Courtney, who pays for testing?
Thanks, Brian. So simply put, the ETS does not require employers pay for any costs associated with those weekly testing requirements that Brian just discussed. Specifically, under a section of the ETS, it mandates that employees must provide documentation of their COVID test result to their employer upon return to the workplace. And a note to that paragraph G1, states that the section does not require the employer to pay for any costs associated with that testing. The note continues to state that employer payment for testing may be required by other laws, regulations, or collective bargaining agreements or other collectively negotiated agreements, and we'll talk about those here in just a bit. Lastly, that same note says that the section does not prohibit employers from paying for costs associated with the testing requirements of that G1 provision. OSHA has stated that the agency leaves the decision to the employer. And because of that, OSHA expects that some workers and or their representatives will negotiate the terms of payment. So what do you do as the employer? Well, there's a few possible options. Employers can pay for the testing. Employees can pay for the testing. Employers and employees can split the cost of the testing, and so many other possibilities. And that's because of the flexibility that's provided by OSHA. Employers have the freedom to set up their ETS compliant policy as long as it conforms to the provisions of the ETS and other applicable state and local laws. So as the employer, how do you decide how to move forward, especially as we're in this gray area of the rule being stayed, but still needing to be prepared if the rule does move forward? Well, first, you need to make sure that there are no state and local laws which mandate employers carry the cost of medical testing. States and local jurisdictions will either explicitly prohibit the shift of the cost to the employee, states such as California, Illinois. Some of them will hint at a prohibition, like Colorado, Montana, Ohio, Oklahoma. Some will explicitly allow the shift, like Arkansas and Wyoming. And some states just stay silent on the issue, Missouri being one of those. Sometimes the state or local law will specify if it applies to all employees or to job applicants only, so make sure that you check that out in each of your jurisdictions as well. Secondly, you want to check to see if there are any requirements from collective bargaining agreements or other collectively negotiated agreements, because those can be a factor and come into play as well. Third, and this is where a lot of employers are trying to determine how they want to set up their program now, because they want to see how that decision may impact their workplace. We're seeing that in some areas, possibly the employers decide to pay for the testing or want to pay for the testing because of high turnover rates in their industry. And they want to make sure that they maintain job retention, employee satisfaction, and have less employee relations issues. Others are maybe shifting the cost of the burden to their employees to not have a mandatory vaccination policy, but to encourage that their employees choose the vaccination route to avoid those costs. Some other considerations that employers should think about is how much of their workforce does this apply to? Maybe polling the workplace. Some employers already have mandatory vaccination policies set up, taking a look at those, seeing what employees are remote, what employees work outside, how that applies to the rule, as Brian talked about earlier. And also just seeing how many employees will actually need to be tested. Another consideration that some employers are looking at is within one company, how can we have different policies that apply for different areas of the workplace? For example, take a company that has customer-facing positions and office-facing positions, or I'm sorry, office-setting positions. Perhaps there is that mandatory vaccination requirement for those individuals who work in the company that are client or customer-facing, and the option to do weekly testing and wear the mask for those in an office setting. These are all considerations that each individual company, employer, client wants to look at to make sure that their plan fits best for their industry. Now, as Brian discussed a little bit earlier, there's some other payments that we need to take into consideration. Kind of going to work backwards on this slide and looking at that payment for time for vaccination and leave to recover from vaccination side effects. OSHA has stated that the ETS requires that employers support employee vaccinations by providing reasonable time off, which can include up to 4 hours of paid leave for each primary dose of the vaccine. Right now, we know that's the 2-part series or the 1-dose J&J shot. And of course, we'll be looking at how boosters can be applied later if and when this rule goes into effect fully. OSHA has stated that over 4 hours would be rare, but if an individual needs to take over 4 hours for a vaccine, then it can be unpaid time, but yet it's protective leave that they received during those extra hours over the initial 4 hours. And employers can't require employees to use accrued paid leave during that time either. Additionally, employers should be mindful that pay differs depending on if the vaccine is during work time or after work hours. Like we mentioned, 4 hours during a workday is reasonable. However, maybe there's no paid leave for vaccines that take place not during the workday and not during work hours. There's also no obligation to pay for the transportation to receive the vaccine. We're talking about gas money, bus fares, things of that nature. And also not obligated to pay for transportation or travel from alternate work locations to the workplace for a dose. Think about those employees who are teleworking to the office for the vaccine. Additionally, OSHA mandates that you need to provide for reasonable time and paid sick leave for those employees who are recovering. And it's presumed that 2 days is what would be reasonable in those instances. Now, taking all that into mind, employers also need to check for FLSA considerations for payment of time it takes employees to get tested. Additionally, and Rufina will talk a little bit more about this here in just a few minutes, if testing is a reasonable accommodation to a mandatory vaccination policy, employers should consider the cost associated with that accommodation, as it's not necessarily part of the ETS's initial plan to transfer the cost, or at least be able to transfer the cost for the optional testing. But when it's being used as an accommodation, employers should think about that aspect as well. And then lastly, the ETS does not require, nor does it prohibit, employers to pay for any costs associated with face coverings. Although employers' payment for face coverings may be required by other laws, regulations, or again, collective bargaining agreements or agreements of the like. So make sure that you are aware of what is in place for your workforce. And with that, I think I'm going to pass it over to Rufino for a little more discussion about accommodations. Thank you.
Thank you, Courtney.
Rufino, if you don't mind, real quick, there's several questions that we received about MSHA, the Mine Safety and Health Administration, and the mining industry generally, and where MSHA stands with regard to the vaccine mandate and the ETS. Real quick, just so everybody's clear, if your employees or minors or your work site is regulated by MSHA and not OSHA, you aren't covered by the ETS. There is no vaccine mandate. MSHA has no current intent no plan to issue an ETS that's applicable to mines or mine sites. That's the good news. Now, however, if you are an employer who has employees that are regulated by both MSHA and OSHA, those employers who are regulated by OSHA will be covered by the ETS. So please keep that in mind. Sorry about that, Rufino. I just wanted to get that in real quick.
No problem at all. Thanks for that clarification. And I'm sure that anybody who had those questions appreciates that clarification. So with respect to accommodations, there's been a lot of questions about what sorts of accommodations is an employer going to be required to provide. And from the OSHA ETS perspective, it is limited to medical objections for one, and those would be essentially covered by the ADA process. So if you are at all familiar with the disability accommodation process, it is the exact same process that you would have to go through, the interactive process with the employee. You can solicit information from that individual about his or her medical condition that might prohibit him or her from obtaining a vaccine if you choose to go the mandatory vaccine route. Alternatively, it would be the testing. We've seen some objections to some testing as well. Those issues you really have to handle on a case-by-case basis and try to identify, really drill down into what the basis for that objection might be. But with respect to the medical question, one of the issues that has been a fairly hot topic has been, well, what do you do with the employees who are pregnant or are nursing, maybe are trying to go through fertility treatments? How do you address their concerns? Is that a legitimate basis for an exemption under the ADA? And essentially, there's somewhat of a conflict in terms of what the CDC is recommending and what some individuals might fear, are potential complications or issues that they don't want to have to deal with by getting vaccinated. The CDC, its latest guidance is still that pregnant employees should be getting the vaccine. They are safe and effective for individuals who are pregnant, so that is something to consider. But more importantly, I think, and more practically for you as an employer is, well, what do you do with that individual? They have a concern, it's a safety concern, and because they're pregnant, even though the CDC is saying that the vaccine is safe, how do you address that issue? The EEOC, as you can see on the slide, has said that those employees who are not vaccinated because of a pregnancy may be entitled under Title VII, that's the Pregnancy Discrimination Act for our purposes here, to certain adjustments, right? And so what do you do? Do you give them an exemption because of that? It really is going to come down to, if you are offering other employees accommodations because of a medical condition, the EEOC has essentially said you should at least offer those same accommodations to an employee who is pregnant, right? So if work from home is an option and you're allowing other employees to work from home as an accommodation, you should offer that to an employee who is pregnant, as opposed to requiring those pregnant employees to just get vaccinated if that's the policy that you implement. So again, it really is going to come down to sort of an employee relations issue. The EEOC has at least indicated that you should offer them equal treatment to other employees with medical conditions or disabilities, and then kind of take the calculus from there. The other exception that is at least recognized under the ETS is for religious objections. Now, this accommodation analysis is exactly the same in terms of the process as it is for disability or medical accommodations. You go through an interactive process with the employee. You as the employer are entitled to ask certain questions about the basis for the objection. You can ask things like, what is it about your religion, or what aspect of your religion is it that prevents you from obtaining this vaccine? And then you go through that process and try to determine whether there is an alternative that you can offer that individual after you've had some of those preliminary discussions. The difference, and it's a significant difference, between a religious objection and an objection for a disability or medical condition is that under the religion analysis, if the accommodation that is being proposed, whether by you or or if it's being proposed by the employee, creates more than a de minimis cost for you as an organization, then it is no longer considered reasonable, and you do not need to provide that accommodation. And again, that's a significant difference from the ADA analysis, which under that process, the accommodation becomes unreasonable if it creates, an undue burden, which is defined to mean a significant difficulty or expense to the employer. So you have a lot more leeway in terms of granting or denying, and especially denying, religious objection accommodations to the vaccine requirement. So, and again, this is a two-part analysis in terms of assessing the request. For religious objections, you can look at, is the employee's belief sincerely held, right? That's the first part of the issue. The second is there a reasonable accommodation? A lot of employers are getting caught up in the, should we assess the sincerely held aspect of this accommodation process? How much emphasis do we put on that? You can certainly have a process where you try to vet those employees who are not necessarily being sincere in making that request. It might be that they have political objections or some other objection to getting vaccinated that is not either a medical or a religious-based issue. But again, because you have so much more flexibility in denying an accommodation because the reasonableness threshold is much lower, I believe that it is more productive to focus on that side of the analysis. It prevents going down that rabbit hole of trying to determine whether somebody is, truly believes what they're telling you in terms of their religion. It avoids some of those, preliminary issues that could trip up an organization from a legal risk standpoint. Whereas, because you have so much more flexibility, it just makes more sense to really focus on that accommodation side of the equation here. But I mentioned political objections. That is something that we've gotten a lot of questions about, employees who might have an objection just because they don't agree with the political aspects of this. They might think that it's unconstitutional to request or require them to get a vaccine, those sorts of things. Those are not protected under the ETS. And, if it's not an objection that is based on either a medical condition that qualifies as a disability or a sincerely held religious belief, anything else is not protected. And OSHA is going to want to see employers enforcing the mandate. If you're going forward with a mandatory vaccine policy, they're going to want to see that policy being implemented on a good faith basis by the employer. That creates somewhat of a conflict to a certain degree with the priorities of the EEOC, for example. And that is something that I think we're going to start to see come up if the ETS is actually implemented at some point down the road. So it does put employers in a fairly difficult position. Do you just grant everybody's exemption request who is saying they have a political objection? That's a possibility. It's a possibility that comes with some risk. And if you're considering that, I would suggest that you discuss that fairly in good detail with your employment or labor counsel. And then the other issue that I'll raise here just very briefly is for any of you in the audience who have unionized workforces, everything that I'm saying is really going to be, to some degree, could be subject to collective bargaining. And so the NLRB just published a memo, a guidance memorandum stating that implementation of the ETS might require some bargaining. These accommodation issues are sometimes issues that are specifically addressed in a collective bargaining agreement. So if you do have a unionized workforce, I would suggest that you go review that CBA, the collective bargaining agreement, talk to your legal counsel about the implications of the ETS and the accommodation issues in particular, and determine whether you have a bargaining obligation, both in terms of how you decide to implement a policy, your policy, and what obligations you might have in terms of making accommodations to employees who are covered by those CBAs. Again, this is just more of a discussion of the differences in terms of the standard for granting accommodations. One issue that has come up on the medical side and the religious side of this discussion has been, what do you do with employees who are requesting these religious accommodations when you have an employee that has a legitimate medical reason for, and I don't say that to mean that there are illegitimate requests for religious accommodations, but if you have a legitimate medical exemption, an employee who maybe is allergic to an ingredient in all the vaccines, what do you do about that employee and their safety when you have other employees who are saying, because of my religious beliefs, I cannot get the vaccine? How do you accommodate those issues? How do you account for the potential increased risk to the employee with a medical condition? Those are all issues that you certainly have to consider, and you're going to have to assess on a case-by-case basis, and ideally with some assistance from legal counsel so that you can arrive at the most informed decision that you can based on the circumstances. So again, realizing that none of this is easy, and that you're going to be in a position of having to make some very difficult choices. It's a lot of this is really, unfortunately, sort of it depends analysis. And then in terms of the types of accommodations, whether it's to a vaccination requirement policy, you've got mass remote work options, and unpaid leave. None of the regulations, none of the guidance in the OSHA ETS says that an employer has to discipline employees who do not comply with their policy, whether it's a mandatory vaccine or a masking and testing policy. It's entirely up to you as the employer how you address those scenarios. And the only caution that I will give to all of you is that no matter what policy or what stance you take, whether it's if we can accommodate, you have to comply, and then you go through a progressive discipline policy after you've warned that employee, that they need to comply with the policy, and then you reach termination. Whatever it is that you end up doing, the most important thing to consider and to keep in mind is that you just need to be consistent, because I can see scenarios where an employer might treat an employee differently in terms of the policy requirements, and that just creates additional risks that you don't want to have to deal with, like discrimination claims and things of that nature. So again, consistency is going to be key regardless of which approach you want to take in terms of non-compliant employees, and you just have to make sure that you drill that into your supervisors, into your HR personnel, so that they understand what your policy is and how you want those individuals to be treated if an accommodation is not possible. And
Rufino,
yes.
Rufino, there were a couple of questions, several questions really about the addressing the sincerity or evaluating the sincerity of religious accommodation requests for accommodation or an exception from the testing in addition to the vaccine. And I know that I was surprised to see that several clients had received those types of requests. And I wonder if you could address that. I think that goes to your point about not digging too deeply. There's no obligation on your part as an employer, and there's risk involved with digging deeply into the sincerity of those beliefs, but perhaps you can address that.
Yeah, absolutely. And so whether it's a religious or a disability accommodation request from an employee, we've seen those come up in terms of testing. And even with masks, we've had certain employees claim to their employer that, they can't wear a mask because it's against their religious beliefs. You have to address every single one of those requests, again, individually. You have to consider the potential issues. If somebody doesn't want to get tested, and let's say under the ETS, those are really the only alternatives, right? You either get vaccinated or you get tested and masked. And so if there's a request based on a religious belief that the employee cannot submit to testing, the EEOC has said, to a certain degree, that an employer can consider, some of the safety issues when it comes to making or granting those types of requests. So as an employer, if you make a determination, I cannot risk this employee coming in untested and potentially, infecting or spreading a virus to other coworkers or your customer base or patients, whatever it might be, if that's what you want to base the denial on, that is something that the EEOC has given some approval for, and OSHA certainly, I think, would get behind that sort of an analysis. Again, the key is going to be going through that analysis on a case-by-case basis, looking at this employee's day-to-day activities. Do they interact with other coworkers regularly? Do they interact with your customers or other members of the public? Those are all the things that you have to consider. And again, those will vary from one employee to another if they have different job roles. So, following the process is really going to be the key, and making sure that you have consistency in how you address those issues is also very important.
Great. Thank you. All right. In the time that we have left, I want to cover real quickly the pending legal challenges and what they mean right now for employers who are looking at their obligations under the ETS. First, as I said at the outset, OSHA has now formally or officially said that it is not implementing and it is not taking any action to enforce the ETS right now until further legal action. Now, it hasn't said what further legal action it is referring to or what it means by that statement, but right now it is not taking any action to implement or enforce. This rule was challenged in every circuit in the United States. So all 12 circuits received challenges, petitioners filed in those 12 circuits. The challenges include 27 states and a host of private parties, including unions and private individuals. When all of the circuits, or when more than one circuit rather, receives a challenge to a rule such as this, the federal court system holds a lottery to determine which circuit is going to decide all of the cases that are consolidated then in that circuit. That was held yesterday. The circuit that won the lottery is the Sixth Circuit. The Sixth Circuit is its headquarters is in Cincinnati, but it covers the territory of Ohio, Michigan, and Tennessee, also Kentucky. That's in essence, I always view the Sixth Circuit as my home circuit. Right now, there are 16 active judges. 10 were nominated by Republicans. 6 of the 10 were nominated by President Trump. It is considered a fairly conservative to middle of the road circuit, but it is also considered a fairly sophisticated circuit. So I expect that they will be very thoughtful, whoever the panel turns out to be. And the way that it will work is that 3 out of the 16 judges, although possibly some senior judges could be in the mix, but 3 judges will sit on a panel to decide both the merits of an injunction, injunctive action, the stay, which is currently in effect, and I'll address that in just a second, but also the merits. This case will move very quickly, and I don't mean very quickly just by legal standards or by government standards. This case will move quicker than almost any other type of case that you see when it comes to rulemaking. And what I mean by that is it could easily be the case that we see a decision on the merits from the Sixth Circuit in the next 2 to 3 weeks, which is, I promise you that by the standards of the legal system, that is blazingly fast. Most people, the consensus seems to be that regardless of which party wins that case, wins on the merits, that the case will find itself before the Supreme Court. I don't know that the Supreme Court will take the case. It won't be obligated to take the case, but it may. If it does, that case will also move very quickly. And very quickly, again, will mean in the Supreme Court's case, probably more like weeks or months, single-digit months, rather than something like 3, 4, 5 months. So we will likely have a substantive legal decision on the legality of the ETS in the next few weeks. In the meantime, OSHA has said that it will abide by the decision that was issued by the Fifth Circuit before these cases were consolidated to stay proceedings, to stay implementation and enforcement. The Fifth Circuit panel issued that decision. First, it stated the day after the rule was promulgated or published, right? So on November 6th, it issued a stay saying, we have grave constitutional and other concerns. We are staying the effectiveness of this rule, the implementation of this rule. 6 days later, on November 12th, last Friday, it issued a substantive decision. And I will say that in my world, it issued what we would consider to be a very strongly worded opinion questioning the validity of the rule. Here are some of the statements that the Fifth Circuit used. Now that the Fifth Circuit doesn't have the case, though, there is a question as to what the Sixth Circuit will do with the stay that was issued by the Fifth, and whether it will take further action to enjoin the enforcement or the effectiveness of the rule. I suspect that we will know the answer to those questions either later this week or next week. So we're waiting to see what the Sixth Circuit will do. It just got the case yesterday, but I expect that this will occur very quickly. And then again, we should have a merits decision very shortly thereafter. As for the chances of success for OSHA, the chances of success aren't very large. OSHA has a terrible track record when it comes to defending ETSs. Since 1971, since OSHA was created, what we have are 10 now total, prior to this rule 9, emergency temporary standards issued by OSHA since 1971. 6 were challenged. OSHA lost 5 out of those 6 cases. And I do believe that this rule goes well beyond any of the prior emergency temporary standards that OSHA has issued. So just on, not the constitutional issues with this rule, but just on the burden that OSHA carries under the OSHA Act for any emergency temporary standard, I think OSHA is going to have a difficult time convincing a court that this emergency temporary standard is authorized by the Act. There are additionally some constitutional issues or constitutional claims that the petitioners have raised and that the Fifth Circuit took quite seriously. That adds some difficulty to OSHA's case, to OSHA's defense of this rule. But I will say, just under the Act, OSHA is going to have an uphill battle here. That doesn't mean that the rule won't survive. It could very well survive. It is possible that the rule will be upheld. So I'm not saying by any stretch that OSHA doesn't have any chance. It does have a chance. But unlike most rulemaking challenges, the chances are in favor of the challengers. So again, what does that mean for you? What do you need to do right now? In the short term, what I would say is this: particularly if you're in a state that bars you from taking certain actions related to your employees and the vaccine or testing, comply with those state laws in the short term. The ETS preempts those rules, or those laws rather. All state local rules are preempted expressly by the ETS. Now, that will be challenged. Preemption is a question. It's a very complicated question to answer, but expressly the rule says you're not to follow those state or local rules. You're only to follow the ETS. Okay, but that's stayed right now. So what I would do to ensure that you do not violate a state law is I would comply with that state law until the stay of the ETS is lifted or otherwise addressed by a court. All right. That's the first part of this. The second part of this is, okay, we know that we have this December 6th and this January 4th deadline coming up. Those deadlines are still there. OSHA hasn't officially changed them. I would be very surprised if it doesn't change them, if it doesn't move those deadlines at some point. Certainly the January 4th deadline It may even move the December 6th deadline. Right now, it's said that it will not do anything on either of those days or at all until there's an additional opinion from a court. But if the court decides the case on the merits in OSHA's favor before December 6th, OSHA could very well enforce on December 7th. It could do that. Again, I don't expect it will. I think that the deadlines will be pushed if the rule survives. Again, I think the chances that the rule surviving are not in OSHA's favor. But it is very worth your while to both prepare for the possibility that those deadlines will not move, that the December 6th deadline will stay. Take a look at it, see what it is that you're going to have to do, and think to yourself, okay, can I comply with the deadline if it's moved to December 12th or December 31st or January 5th? Prepare for that in advance. Try to keep in mind that a lot of this is very much a moving target. And I know that that's frustrating, but that's where we are. And with that, I believe we've gone over for those of you, and I believe that everyone has stayed with us. We really appreciate it. I want to be mindful and respectful of your time. We received quite a lot of questions in the Q&A. We will do everything that we can to get to those questions and to respond to you. For those of you who would like to share this presentation will be made available to you, and we will email out links to the presentation and to the answers to the questions that we received. And with that, Rufino or Courtney, would you like to say anything?
Yes, thank you all for joining us today. We hope this information was helpful to you and your organization. Just some quick reminders. The program has pending approval for legal education hours. To report your hours, click on that CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. And then be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. And this concludes our webinar. Thank you.